and they corroborate each other each time. You're not going to change one of those by bringing those people in. So as senators, I think, get more acquainted with the fullness of this record and with each part of what it says, I have a suspicion that that debate also could change.
Judges and presidents shouldn't be held to the same accountability.
Look, you can go back to President Ford when he was in the House and the statement which is often quoted by him that makes it very clear that the Republicans in the House of Representatives at the end of Richard Nixon's impeachment made very clear statements about how the standard between judges and the president was different. It is only now for William Jefferson Clinton that they are trying to change that standard. And I don't think that the constitutional reading and the legitimate reading of precedent allows you to make that transition. The standard between the president and judges are different. And secondly, and very importantly, the underlying cases of Claiborne, Hastings, and Nixon each were criminal activities that were being investigated. In the case of the president, the underlying activity was personal and private. It was sexual. And there is a huge difference in whether or not that interferes with his public responsibility in the same way that the public responsibility of those judges were interfered with. So there is an enormous distinction here, and we need to keep that in mind.
To clarify your stand on
Massachusetts Democrat John Kerry reflecting that Charles Ruff's performance today, presentation today, I should say, was strong enough so that in Kerry's opinion, it may cause senators to shift in their view about whether or not witnesses would be necessary. At the end of the 3 days of presentation by the House managers, it was beginning to look as if witnesses were inevitable. Now you hear Senator Kerry, and no doubt others will say Democrats will make the case that that's not so. Bernie?
Charles Grassley is a Republican senator from Iowa. He joins us, having just left the chamber. What's your impression, Senator?
Well, first of all, I think without a doubt we learned today what we said last week, that we really shouldn't make too much of a comment because we've got to listen to the other side, and usually the other side's pretty forceful as well. Well, we found today that Mr. Ruff did present a forceful case, an emotional case, and we've got 2 more days of it, so I don't want to draw too many conclusions, but let me say that it seems to me that they spent a great deal of time criticizing process. They did challenge some of the facts, and with the evidence that was before us, the facts that they challenged, although it was a small number of the facts, they seem to have some documentary evidence that would indicate that they've got a good grounds for challenging those facts. But I do think this, that the House, or the White House, for some reason or other, and also some of my Democrat colleagues, are spending an undue amount of time on whether or not witnesses should be called or not called. And I think Mr. Ruff went into a portion of his testimony today that raised the specter that, well, you folks are really in for a shock if you think you're going to get any information out of witnesses. The fact is, we've got to seek the truth. And I don't know whether we need witnesses or not, but I know that it seems to me that there seems to be too strong of a case and too much time put on the White House trying to make a case for that there shouldn't be witnesses, and why.
Senator Grassley, your colleague from Iowa, a Democrat, Tom Harkin, just a short while ago said that Mr. Ruff poked holes the size of a barn door in the prosecution's case.
Well, and you want me to react to that?
If you would.
Well, I'm glad to react to that. And each one of our colleagues is going to interpret this information that we get today just a little bit differently than somebody else might, as jurors do in any trial. The bottom line of it is, I said that he did have some challenge to facts that we have to consider. There are lots of more facts out there than the 2 or 3 that he actually challenged. Now, he could have poked a hole as big as a barn door, as Senator Harkin said, in the testimony on one fact. But there's lots of other facts that we have to expect some disagreement on the part of the President's counsel, or else maybe they aren't really challenging the case effectively to get acquittal. But right now, it's too early to draw any judgments.
One more question, Senator. What will push you over the top as to whether or not there should or should not be witnesses?
Oh, I think 2 more days of this and 2 days of questioning by senators, and then we're going to have 3 hours of debate on whether or not we need witnesses, and I think it's at that point that I'm going to make that judgment. But one thing you want to remember on the vote that we'll have next week...
Next Monday?
Next Monday on the question of witnesses is a general one. In a sense, should we call some witnesses? Then we're going to have an opportunity later on after depositions to make a decision if specific witnesses should be called. And I think if those depositions are important to get and read, maybe the door should be open to possibility of some witnesses. But the final decision on that will be made by me next Monday. And to answer your question, what pushes me over, our goal is to seek the truth and to make sure that the President gets a fair trial. And if that can be done without witnesses, then I'll vote against witnesses. If it takes witnesses to give the President a fair trial, then I'm going to vote for witnesses.
Well, it couldn't be stated any clearer than that, Senator Grassley. Thanks so much for joining us.
Thank you.
Quite welcome, sir. Judy?
Aside from the 100 senators themselves, no one surely was listening to today's proceedings any more closely than the 13 House managers, the prosecutors in effect, who made their case before the Senate earlier this week. Let's listen to one of them, James Rogan of California.
Trying to imply that the President somehow was doing this just to protect himself from embarrassment. Well, we know that isn't true. We know it isn't true factually, and we know that isn't true from a common sense perspective. Because when the President went before the grand jury on August 17th last year, embarrassment was off the table. The FBI already had Monica Lewinsky's dress. They knew the DNA results. The President went on television just a few hours after that, admitting that he had had an improper relationship with Monica Lewinsky. Embarrassment was no longer at issue. The President used the grand jury and used his time in testifying before the grand jury to continue the perjurious answers that he had begun during the Paula Jones deposition. And that's important to remember, because he wasn't ordered by a judge to answer those questions to him just for the sake of embarrassing himself. He was ordered by a federal judge after the United States Supreme Court had paved the way for him to answer those questions as a defendant in a sexual harassment suit. Paula Jones, as a plaintiff in that case, as a plaintiff in a sexual harassment suit, had the right to get those answers. He perjured himself in January and obstructed justice to keep her from getting those answers. He continued with that perjury in August before the grand jury, and he didn't do it to save himself from embarrassment, because the facts were already out by then and he was ready to confess them that night. I'd like to invite Charles Kennedy to step before the microphone so that he can also comment on the legal aspects of the case.
Thank you very much. I wanted to join my colleagues in expressing my compliments for the legal skill demonstrated by Mr. Ruff. He is a very capable lawyer, and I think he's done a good job in making the best of what is an inherently weak case, which he has to present in defense of the President. I am particularly troubled by the standard which Mr. Ruff continues to articulate, which he suggests the Senate should use to judge the conduct of the President of the United States. I do not believe that he has expressed any convincing rationale for the Senate establishing a lower standard of integrity for the President of the United States than the standard the Senate has already established for federal judges. There's nothing in the text or the structure of the Constitution to suggest that high crimes and misdemeanors committed by a federal judge, the same acts that would constitute high crimes and misdemeanors committed by a federal judge, are suddenly transformed into something other than high crimes and misdemeanors if they are committed by the President of the United States. I would have to say that I believe that that's an argument that just does not make sense. I was also disappointed that the President's lawyers have chosen to continue with the legal hair splitting in the point they make concerning the form in which the articles are cast. It is clear from the very earliest days of the history of impeachment in this country that articles of impeachment are not held to the same standards that would be applicable to an indictment, for instance. Alexander Hamilton specifically addressed that in one of the Federalist Papers. Justice Story addressed that in his commentary on the Constitution. So the legalistic challenge to the articles and the form in which they're cast, I think, is an unfortunate instance of the President and his lawyers seeking to turn away from the actual facts of this case, to turn away from the substance of what has been charged against the President, and to find refuge in some technicalities which don't stand up to analysis. Lindsey Graham will now address the legal issues as well.
We are going to leave the House managers for a moment and go to the Senate portion of the Capitol to talk with Republican Senator Wayne Allard of Colorado. Senator, you were able to listen to Mr. Ruff's presentation. Is your thinking where it was a day ago?
I think he did a very good job. It was a little difficult to hear him in the Senate chambers. He had some problems with his microphone there, the first part of his presentation. So you had to lean forward pretty hard, struggle hard. I tried not to comment on the facts because, again, I took an oath of impartiality. I want to keep that in mind as we talk about the trial here. But I think it was shorter than I anticipated today on his presentation, but I think he did a good job.
What about when he went down the list, and we've just been listening to some of the House managers say that he really only went after a few of the facts that they had presented. But what about when he went down the list? For example, when he pointed to the December 11th chain of events, when it turns out that Judge Wright didn't make that order until late in the day?
Well, again, on those facts, that's something I made a note of in my mind. And as we go through the process and make my deliberations, I will keep it in mind. I think that the House managers did a superb job of making that presentation. I think he did a good job of counteracting a few of those points. I've made notes on them, and when the trial's all over with, or at that point where I need to make a decision, then I'm going to make that's one of the things I'll take into account probably.
Senator, it's Jeff Greenfield. I don't want to take you through the facts, but I do want to ask you about a standard, which is something you might be able to talk about. Chuck Ruff said you should not remove the president just because it's acceptable. The only way that you can justify removal, it is the only remedy. Do you agree?
I think that the president should have the same standard as anybody else showing up in court. I think that's what the forefathers intended when they wrote the Constitution and set up this country, and I think that's the standard that we need to keep in mind. I don't care whether it's a member of the House, a member of the Senate, or the President, or a Chief Justice. The law needs to apply equally to all citizens of this country.
But he was suggesting that you might find the president violated the statute on perjury, let's say, and still not remove him because you think it was the nuclear weapon, that you shouldn't use that in this case. If you found that he did these acts and that these acts are impeachable, removal is what you will do? Do I get that right?
Well, I will look at all the information. I don't want to characterize the facts or characterize that testimony, but again, I have an underlying philosophy. I've stated it over and over again that I think the president ought to be treated like anybody else, and I have that same standard whether you're a member of the Senate or the House or you're a member of the judiciary. I think that's the strength of our system, and then we'll look later on after we get the facts, the strength of whether they're strong enough case to warrant an impeachment vote or not.
At this stage, Senator, how large a burden does the White House have to refute, to rebut the charges put forward by the House managers?
Well, they did a very good job, and the president's team got off to a good start today. They've got 2 more days of testimony, and we'll see how they wind up now for the next 2 days.
All right. Republican Senator Wayne Allard of Colorado. Thank you. Bernie.
California's Democrat Barbara Boxer is talking now to reporters.
It was powerful, and I think Mr. Ruff, when he started off, it was almost that you had to strain to listen to him, and then he brings you into his thought process, and at the end, well, you could have heard a pin drop. I thought it was really very, very powerful.
Create even more of a need for witnesses?
Not in my view, no, because it's all on the record. You can read the record and decide for yourself what the facts are from the record. I mean, how many times does Monica Lewinsky have to be deposed on the same question over and over again? So no, I think if anything, what was shown is that if you read the record, you can make your decision. And some will decide on one side and some will decide on the other.
Yeah, I think the presentation by Mr. Ruff today demonstrated why having witnesses will really contribute nothing to this trial. We have a record. Monica Lewinsky has been deposed or testified under oath 22 times. Mrs. Curry somewhere around 8 times. I mean, the fact is we have a complete record, and both sides will use that record to make their particular case.